Thank you all so much for joining us today for what I hope is going to be a very insightful and interesting webinar uh, by Tessa, who's our keynote speaker, as well as our panel of speakers who have great expertise. I'd like to quickly introduce myself first, and then I'll give a really quick context setting before I introduce Tessa Boyd-Caine. So I am Priya. I am a senior policy officer with the National Forum. The National Forum is the peak body that represents 14 national family violence prevention legal services that are Aboriginal and Torres Strait Islander community controlled. We are a peak that represents, as I said, 14 member services spread across Australia. We have today one of our also peak members who you'll hear from as part of the panel. I just wanted to give a really quick, I guess, introduction before we have our keynote speaker on about, I guess, a bit of context for today's webinar. We know that efforts to achieve gender equality in Australia has to recognise the crucial role that access to legal assistance plays for women. And we also know that the legal assistance sector works directly with women facing systemic barriers to gender equality across Australia. We know that this is compounded, especially in legal services working with victim survivors of domestic violence. Importantly, we know that there is a significant overrepresentation of First Nations women and children who access these services due to structural barriers and racial and gender inequality. So the importance of legal assistance for women for specific communities becomes even more pronounced. So to help us, I guess, lead and inform this discussion, we have Tessa Boyd-Caine, sorry, Tessa. Tessa was born and grew up on Gadigal land in Sydney, where she continues to live, learn, and play. Tessa is the recently appointed CEO of ANROWS, and until 2024, she was the founding CEO of Health Justice Australia, the National Centre of Excellence for Health Justice Partnerships. Tessa has previously served as the Deputy CEO of the Australian Council of Social Services, ACOS, and was the inaugural Fulbright Professional Scholar in Non-Profit Leadership. So without further ado, would love to welcome you, Tessa. Thanks for joining us today. Take it away.
Thanks, Priya, and hello, everyone. Really lovely to be joining some old friends as well as some new ones. And I want to extend my acknowledgement of country. I'm joining from the lands of the Gadigal people, lands that always were and always will be Aboriginal lands. And particularly in the context of this discussion today, I really want to reflect my ongoing commitment and that of ANROWS, the organisation I lead, to walk alongside and support the leadership of Aboriginal and Torres Strait Islander people and communities towards ending gender-based violence, particularly for women and children in this country. So Priya mentioned I'm the recently appointed CEO of ANROWS. I'm in week 5 in this role. And so I come into this webinar with a really, really strong understanding of the role of legal assistance for addressing gender equality. But at 5 weeks in at ANROWS, I've got a growing sense of all of the work that we do that I'm not across. And so I'm giving you that context to frame up that the evidence I'll be talking about is specifically evidence that ANROWS has had touch points on, but recognising that there's lots of expertise that sits in the webinar as we're going live and in the context of legal assistance work more broadly that I won't necessarily touch on. ANROWS is Australia's national research organisation for women's safety, and we were established as an initiative of the first national plan to reduce violence against women and their children. And so that's a plan that was led by the Commonwealth and all state and territory governments in Australia. So while we're a national charity and we're an independent organisation, our primary function is to build the evidence base that supports ending violence against women and children in Australia. And so that gives you a bit of a sense of some of the evidence that I'll speak to later. But really, in this conversation, there's 3 things that I think stand out for me that are really the things that we should be talking about. And the first is just to really reflect the title of the webinar. There is a crucial role for legal assistance in achieving gender equality. And I also think there's some work to do, and I think this is a great group of people to have that conversation with. So I'll come to that in a moment. I am going to talk a bit about what the evidence says, particularly drawing on the insights from ANROWS' research, and that's both research that we've undertaken and that we've commissioned from others. And then I wanted to finish with ways of working to improve gender equality. And I see the role and impact of legal assistance, both in terms of the work of the sector, the practitioners and the communities that you work with, but also the opportunities in terms of working collaboratively, including with organisations like ANROWS. So to start, I mean, what is the crucial role for legal assistance in achieving gender equality? And where is there room for improvement? And to start with, I think it's really important to recognise the link between gender equality, women's safety and the law. So last week, the federal government released the gender equality strategy, and gender-based violence is the first of 4 priorities in that strategy. So that reflects the really inextricable link to gender equality of addressing gender-based violence. But indeed, the strategy and other work, including last year's Women's Economic Equality Task Force, show that women's safety is also a critical foundation to other rights and entitlements and needs, basic needs. And so those include economic security and independence, health, and access to safe and secure housing. If we understand those intersections, then already you can start to see that there are, in fact, multiple roles for legal assistance in supporting gender equality. First and foremost, I think that role includes naming and enabling women to access their rights and entitlements. That might be the right to safety, it might be the right to adequate income or secure housing, it might be the right to freedom from discrimination, whether that's at work, in the health and other systems, or indeed in our occupying space on the street. So that individual advice to and advocacy for women role that legal assistance services plays is absolutely critical to supporting gender equality. And we know that women who experience violence encounter the legal system and legal needs through a whole range of interacting factors. So in the context of family violence, that might include navigating legal issues around custody or child support, property matters or protection orders. It might, as Priya flagged, include engagement with criminal proceedings where there is applicants, respondents, defendants or witnesses. And from my previous work at Health Justice Australia, the really clear evidence that women who are experiencing family or sexual violence may be experiencing multiple legal needs at the same time. And indeed, those legal needs are often intersecting with other health and social needs as well. So even if all we were talking about was the role for legal assistance in terms of individual advice, support and advocacy, you can see the tentacles, the kind of potential impact of that legal assistance includes but is not limited to justice outcomes. It is very much core to gender equality and the assertion and the attainment of rights and entitlements for women and often for children in the context of family violence. But the second area that I think legal assistance plays a really crucial role in terms of addressing or improving gender equality is in the areas of law reform. And we need look no further than the hard fought for win of the federal government's family law reform package, which many on this call and in the sector more broadly were absolutely critical to achieving in refocusing Australia's family law system on the best interests of children and the safety of caregivers, majority of whom are women. So that advocacy for law reform is a second, I think, really critical role that legal assistance sector plays in achieving gender equality. I want to note also, I think, the role that legal assistance services and advocates play in identifying the risks sometimes of legal responses, particularly to women and children in law reform. And so coercive control is such an important, current and good example of an issue that was made prominent through advocacy, including by legal assistance practitioners and the clients and communities you support. But also the advocacy, the really strong caution about whether coercive control should have been or should be criminalised, as it continues to be in parts of the country, and if so, how. And so that very clear insight, bringing legal expertise to the context of who are the kinds of people who are often over-criminalised, reflecting the evidence, including evidence from ANROWS, about the misidentification of victims and how sometimes bringing into criminal responses issues like coercive control can in fact exacerbate the criminalisation of the wrong people, or at least the misidentification of victims, particularly in the context of family violence. So recognising again that advocacy in the context of law reform isn't only or always about new and different laws. It's also about being very careful about how we use the law and making sure that we hold really core principles like gender equality at the heart of our law reform. So with that really strong support for the framing of this topic in terms of the crucial role for legal assistance, I do want to call out that I think there is more to do. I think there's a critical role for legal assistance in holding systems to account, particularly where systems cause harm or exacerbate vulnerability or disadvantage. And we've seen that role played so well in addressing grave injustices like robo-debt, where legal assistance services, including legal aid, were so critical in writing that horrendous systemic reform. But when it comes to gender equality in the context of the legal assistance sector and in the context of the law, therefore, I do think there's more work to do. And there's two, I guess, indicators for me of what that work might look like. The first is data that I've discussed with Victoria Legal Aid and other legal assistance services that show how men disproportionately benefit from legal assistance, particularly legal aid grants. So even just in the kind of question about which sorts of clients benefit from legal assistance, you can see there's a gender skew, and that has been worsening, certainly from some data points, that has been worsening over the past 10 years. But I also want to pick up some work that I was actually doing most recently at Health Justice Australia with the team there to highlight what I see as a real gender inequity in the provision of legal assistance for some matters and not for others. And the standout distinction for me there is the provision of legal assistance for criminal justice matters where there's a risk of imprisonment, an outcome that disproportionately affects men. But we don't routinely provide legal assistance for child protection matters, including where there's a risk of having a child removed from a family, an outcome that disproportionately affects women, particularly in terms of the caring and kinship roles that women take up. So I say that as work that I think we can do together in the interest of ensuring that our legal assistance is available and is made really core to the contribution that the legal assistance sector can make in addressing gender inequality. I want to jump now to, just to finish that point, I guess I say that to invite comment, and I'd be really interested in reflections from people in this webinar about that issue. But I want to move now, as I've been asked by the organisers, to talk about what the evidence says and to particularly draw on some of the insights of ANROWS' research in this area. And the first thing that I've been asked to touch on is the kind of impact for Aboriginal and Torres Strait Islander women who experience violence, the impact for them in terms of remedies within the law, and what are the kinds of needs and concerns that we need to take account of if we want to ensure that our legal assistance responses are really fit for purpose, are culturally safe, and are appropriate to the needs of Aboriginal and Torres Strait Islander women, children and families. And so the first kind of set of issues that we've supported research on, and this is actually research by Marcia Langton that we resourced, recognises that Aboriginal and Torres Strait Islander women who experience violence often have to balance competing concerns when deciding whether to report that violence and whether to pursue legal remedies in response to it. And so those competing concerns include the risk of child removal, and that's partly why I signal that as a really core issue, I think, for gender equality in terms of who gets access to legal assistance and what for. But we know First Nations women also have to really weigh out the fear of isolation from family and community when those kinship ties are so core to identity and to being for First Nations communities. And we see the threat of homelessness, particularly if women were financially reliant on the perpetrator or the people using violence in that context. If I move then to the service response that Langton research looked at, the call was really for services to be available, acceptable and accessible to Aboriginal and Torres Strait Islander women experiencing violence, particularly in the kind of context of barriers to help seeking. So if we think about availability of services, It's a recognition that there's a lack of housing and early intervention services that give women options when they're looking at identifying and trying to address the experience of violence, particularly in the home. Accessibility, reflecting that Aboriginal service providers are a critically important part of the service landscape, service infrastructure, and making sure that support is available, particularly in a context of often reluctant victims, often victims who don't necessarily want to be engaging with service systems, and certainly not the complexity of service systems, and really just want support to see violence end in the home. And then acceptability was named, particularly in the context of services being culturally safe and relevant. And the research talks about colourblind services and practices that don't actually provide safety for Aboriginal and Torres Strait Islander victims and survivors. There's also really clear evidence, not only from Langton but from others, about alternatives to mainstream legal systems that really support First Nations communities. And so those might be placing a greater focus on diversion from the mainstream legal system into community-owned and place-based structures, enabling the involvement of elders in criminal justice or in other processes, and really recognising the value of working in community, or in social policy language, through place-based approaches, making sure that there is support for First Nations people, that there's a connection to initiatives that might also be taking place in community, for instance around alcohol, and that there's a real respect for and being informed by the principles of trauma-informed responses, social and emotional wellbeing, and alternatives to custody as really critical elements of cultural safety and culturally appropriate responses to the needs of First Nations women, children and family. So that's a bit of a whistle-stop tour through some of the evidence that we've supported and seen really emerge in the context of First Nations voices in responding to violence against women and children, and to really asserting both gender in terms of equality of women, but also recognising role and responsibility for kin and community in that work. If I move now then to some of the other areas of research that I know was particularly of interest in this discussion, there's obviously a huge body of work around family law and family violence, which explores the challenges of those co-occurring issues, particularly in contexts like self-representation. So where, because of a lack of legal assistance or availability of services, women might be left to represent themselves in proceedings. And we've seen in the context of that evidence the really clear signalling that 82% of matters in family law proceedings often involve women or children or both who've experienced family violence. So while we recognise that family law and family violence are not always the same, that there's a whole range of legal needs in the context of family violence that might not be about family law, there's very clear evidence that many family law matters are working around the needs of people who've experienced violence in the home. We also see this real challenge in the context then of family law and family violence, where children are experiencing that violence in the home but are not recognised, often don't have their own voice or option or ability to feed into family law matters, are often quite disconnected from court processes but are not disconnected from the experience that those court processes is addressing. I've talked about those intersections between domestic and family violence with other areas of legal need, and our evidence shows that that's particularly around experiences of disadvantage, marginalisation or discrimination. So that might be around English as a second language, it might be around intersecting factors that connect with drug and alcohol use, low levels of literacy, mental health concerns, homelessness or incarceration. So a whole range of intersecting factors, many of which might have legal dimensions, but often that include factors that move beyond the law, including in relation to health and social service needs or social needs more broadly. And then I think, to sort of pick up that point that I flagged earlier, the evidence is really clear that the legal system can be a tool for abuse. And so if we're thinking about the role of legal assistance in supporting women in the context of legal rights and in asserting gender equality, we need to be really wise to the ways that systems can be used as a tactic of abuse by perpetrators, but also can really fail women, often in the context of making sure that their rights are equally highlighted and that their access to services is equal in terms of remedy for the needs that they face. Now, I'm really conscious of time and this incredible panel of people on the webinar, and also the sort of insights of the audience. So I'm going to jump now. There's a whole range of other areas of evidence that I could speak to, and happy to answer questions on them. But I really want to jump now to the ways of working that I think can continue to support the role of legal assistance as a critical pillar of our responses to gender inequality. And so the first thing to note is that while legal assistance services and the expertise of legal practitioners is really clear and really clearly defined in the role of providing advice to and advocacy for women in the context of their legal needs, I think there's also a really key role for the legal assistance sector to be working collaboratively with other services, with other sectors, and in policy reforms that might have impacts beyond the law. And that's probably no surprise in the context of my really recent work at Health Justice Australia, which is really driving and supporting that opportunity for legal assistance to be part of health and social policy work. So that's in the context of service collaborations, integrated and other services. But I think it's also in the context of building the evidence about ways of working that recognise the intersections I've talked about, that put pressure on policymakers, on service design and system change to make sure that we're seeing the intersection of legal and other need and the opportunities of legal assistance alongside other services to ensure that our service systems do better by people who are facing unmet legal need and by people who are experiencing gender inequality. For ANROWS, we've worked really closely with the legal assistance sector in a whole range of ways. So that includes, for example, in recent work we did around the Safety First in Family Law campaign, which was a Women's Legal Services Australia campaign, pre-pandemic now, I think 2019. But our ability to inform that work saw a really strong evidence base underpinning the 5 steps for reform in the family law system that was identified in that campaign. And as I said at the outset, that some of that work has led to really significant law reform outcomes that we feel really proud of being a part of, that we could never achieve on our own, that we would want to partner with sectors like legal assistance on, but also seeing that that contribution of the evidence base doesn't need to be owned or led within the legal assistance sector. So collaborations like the collaboration that legal assistance services have had with ANROWS means that you can draw on the best of the evidence that's available and leverage that in the really clear and important advocacy work that you do. I think examples like Health Justice Partnership are just one of many examples of how legal assistance services can work collaboratively to really strengthen your own role in terms of addressing gender equality and achieving that impact in the benefit of all of us. So I'm going to end there. Priya, I'll hand back to you, and I'd love to hear from the responses of our panel and from the audience participants in terms of questions and discussion today.
Thanks so much, Tessa. Handing over to me now to facilitate the panel. That was a really fantastic overview of a whole range of ways in which legal assistance is really crucial to achieving gender equality across Australia and internationally. I'd like to start by acknowledging the traditional owners of the lands that we're all on. For me, that's the Wurundjeri people, and I pay my respects to elders past and present. So one of the first I will introduce the speakers on our panel. So we've got the fantastic Kathleen Wincen, a Bundaji woman. She's the CEO of the Aboriginal Family Legal Services in Queensland. Then we've got Elena Rosenman. She's the wonderful chair of my board at Women's Legal Services Australia and also the CEO of the Women's Legal Centre in the ACT. And then we also have Katherine McKernan. She's the Executive Director of National Legal Aid. So the first question I have for you all touches on a really interesting point that Tessa raised, which is around the disproportionate access to legal assistance for men on particular issues, and thinking about what are the particular issues that women are most likely to need legal assistance with. Tessa talked about child protection and the fact that children are often removed from families, and that's most likely to be an issue for women who are primarily caregivers. What are some of the issues that we see predominantly impacting women that could benefit from increased access to legal assistance?
Do you want me to start, given no one's saying anything? Feel free to jump in, other panel members. Yeah, I just want to acknowledge the points that Tessa made in her presentation around access to justice and the disproportionate, particularly with legal aid representation. And I just wanted to note, give a plug for the report that we released late last year called Justice on the Brink, which actually does some analysis around what's happening with the funding between the Commonwealth and state governments. And so Tess is correct. Criminal law grants have increased from 80,000 per year 10 years ago to about 110,000 now. And at the same time, family law grants, for example, have gone from 45,000 grants a year to just over 40,000. So what we've seen is an increase in investment from the state government in terms of criminal law, and a lack of investment in enhancing the family law grants. So I just wanted to acknowledge that that's the case, and working very hard as part of the NLAP review at the moment to really identify and highlight the needs for women and children in particular, and the impact limited family law access has for women and children. And I will stop talking very soon, I promise. So I just wanted to say that just to acknowledge that Tessa did highlight the range of areas where it's specifically, a specific issue for women and children. Absolutely family law and child protection, but I'd also say recently doing some of the work around respect at work too. It's also about discrimination and harassment. Experiences within the workplace are particularly gendered as well. So I just think it's important to think of the broad range of things of women beyond the family, but also in the workplace and in other parts of the community as well.
Thanks, Katherine. And I will take over pointing to particular people because I now recognise that it's difficult to know who's going to talk. So I'll now hand over to Elena.
Thanks, Lara, and thanks, Katherine, for stepping in. We were actually discussing before we started that we would have to remember that we weren't just chatting amongst ourselves. So I think everyone's being a little bit unusually, possibly polite for this particular group of women than they would be. So obviously in terms of the role of legal assistance in driving gender equality, I think, that we would absolutely agree with a lot of the points made, and particularly that it's a driver. I think, lots of the things that are front of mind are around legal assistance as a driver of gender equality when it comes to women's safety, both at home and at work, and their economic security, both post-separation and also in relation to their employment conditions. And having access to employment conditions that actually support and encourage their participation in the paid workforce. And I think that some of the issues that we also see in some of this, in the Women's Legal Services members across, and sorry, I should have mentioned this as by way of starting, Women's Legal Services Australia is the peak body for the 13 specialist women's legal services across Australia. So you'll find a specialist women's legal service in every state and territory, and there are multiple services in some of the bigger jurisdictions, and there are also 2 community-controlled women's legal services within our membership. And I think the other thing that we often see in terms of as an indicator of gender equality is that, and where legal assistance can be a driver, is particularly also in the context of both those issues, safety at home and safety at work and in the world, is the compounding and intersecting issues of visa security for women, for migrant women, and also the issues of cultural security for First Nations women. So in terms of the critical legal issues that we are seeing across our membership here in Australia, obviously it's family breakdown, particularly in the context of DFE, and Tessa is absolutely right to identify care and protection as a space where I think there is a really gross paucity of legal services available. And I think if you want evidence of that, you need to look no further than the data, particularly around the removal of First Nations children, both from their homes, but also from caregiving arrangements that actually protect and drive and celebrate their culture as a source of strength for them. We also see, obviously, sexual violence as a key area of legal need for women, and the issues of, as I've talked about, around conditions at work and respect. And I think and respect and entitlements at work. One of the things that worries me is that that women have access to these services, but it's currently really patchy according to jurisdiction. So in some jurisdictions, there are gender specialist services that can assist with sexual harassment and employment. In some, there are that can assist with migration. There are currently only 3 services nationally that can assist in relationship in relation to sexual violence. So I think one of the issues I'm concerned about in relation to access to legal assistance as a driver of both individual and systemic change is that at the moment, women across the access that you have to legal assistance is absolutely not universal across all the states and territories. So there's a real inequality in lots of areas.
And Kathleen, did you want to add to that? Sorry, you're on mute.
It had to be me. It had to be me. I think I'd like to add to that too is your regional rural and remoteness. For some women, we don't have access. My women in Cunnamulla don't have the same access as what some women in Brisbane, in Queensland, and I think it's that real breakdown of accessibility to resources from different women in different areas of the country, and in particularly in Queensland, because we're such a huge state. It's that breakdown of accessibility to resources, and I think the other women have covered everything else quite beautifully.
Well, that really leads on. Actually, Tessa, you're also on the panel. Would you like to comment on that one as well? I mean, you've already kind of provided a pretty comprehensive summary, I think.
Thanks, Lara. I mean, yeah, obviously the expertise here I think is really clear. Just to signal then, in addition, also remembering those basic foundations of need, like income, and that we remember the role of legal advocacy around adequacy of income, around entitlements, around holding excesses that can curb income as being part of that broad work that ensures and supports women's safety. Women cannot be safe without adequate income, and they cannot secure economic independence if they're not safe.
And I know from Women's Legal Services Australia's perspective, we've really been trying to make the case that women's economic security is so intertwined with access to legal assistance. If you don't have a legal assistance support at that particular time around post-separation, you're much more likely to end up homeless or in poverty, particularly if you're a victim survivor of domestic violence. So yeah, really vital to be making that point, particularly as we talk about, gender equality reform nationally. So that kind of leads to our next question, which is, why are we not having kind of universal access across the country to legal assistance, given that we know it's so fundamental to achieving gender equality? And what are some of the impacts that we're seeing across legal assistance services because we're not being funded appropriately and then need to turn women away? I'll hand over to you, Katherine.
I didn't mean to start first all the times, but I will. Look, I think the impact is really considerable, particularly on individuals and families, unfortunately. We've done a little bit of research recently just looking at who is, what it means to have a means test where only 8% of Australian households are eligible for legal aid, and then also, even if you're eligible for legal aid, I love the cattail. Even if you're eligible for legal aid, there's also a range of guidelines that we've had to put in place because of the resource restrictions. And so often there's multiple vulnerabilities that are required as well. And so what this means for individuals is that you can be in really, really dire financial circumstances with a range of issues that you're dealing with and still not be able to access a legal aid grant because we just don't have the resources to provide it. And, I don't want to hark, the NLAP review is currently underway, so I am going to hark on about the funding because this is our opportunity, but we really haven't seen an increased investment in the family law space in particular for a really long time, over a decade. And so what that means is we've now got a system where you have to be really, really poor and really, really vulnerable to be able to access legal assistance. And that leaves a huge gap for a range of, for people who are doing it tough and require the support, and it will make a huge difference, as everyone else has mentioned, in terms of preventing homelessness and in ensuring financial security and independence. So it has impacts down the track for other services in the community in general. So that's the impact from a legal aid perspective.
And sorry, just to add to that, Katherine, on the other side of that, as a legal aid supplier, our resources are limited. and we have to triage our matters, and it's our vulnerable women that miss out on those services. A woman may come into our service and she's entitled to legal aid, and then she, to better herself, goes and gets a job, and then that legal aid is stopped, and her matter is still ongoing. And it can ongo, especially for a family law matter. It can be ongoing for, you know, sometimes up to 2 years, and that's 2 years she's got to stand in court by herself without that support from a legal provider. And it gets quite tricky, because from a legal aid perspective, and I'm playing the devil's advocate here, we're limited in our resources, so we have to triage our matters. And that's where it's a catch-22 for our very vulnerable women.
Elena?
Oh, I think that Kathleen is absolutely right, that actually at the moment what we have is a situation is where resourcing is driving access, not legal need. And that it's really important to be very clear on that. So from our perspective, what we see is obviously the most obvious result of the lack of resources available to the legal assistance sector as a whole. It is the result that is experienced by individual women who cannot access assistance. So we know that nationally, women's legal services across Australia are preparing this year to turn away 52,000 women. And those, of course, are just the women who know, have enough access to information and resources to know they have a legal issue, to know where to go to get the help, and to have the ability to actually reach out for that help. So, you know, my concern is I don't think that 52,000 is in any way an indicator about what legal need looks like. And I think the information that Katherine's shared with us around actually what tiny percentage of the Australian population is eligible for legal aid assistance specifically is a real indictment of the current funding arrangements. I couldn't help it. I don't know if people have had the opportunity to have a look at the gender equality strategy that was released late last week. And I couldn't help but there was a little story in there about Priya and Luca, who are a couple. And in one scenario, it imagines them living their life in the current sort of status. And in the other scenario, it imagines them living in their lives in a world without limiting gender norms. And, you know, that case study takes the way, you know, it progresses the way you expect, which is, you know, spoiler alert, doesn't work out very well for Priya. It really works out much better for Luca. But one of the things that struck me about that example is that it still relied on, you know, even in the story without limiting gender norms, that actually the intersecting issue of violence and separation was ignored. So one of the things that I think is really interesting is actually what happens for men and women post-separation. And Lara, you've referred to this a little, but what we know is that 15% of women experience financial abuse within their relationship. We also know that post-separation, women's incomes drop by about 21%. They're less likely to stay in the property market. They're more likely to experience homelessness. And we all know that the fastest growing group of homeless people in Australia is single older women, not older women per se, but specifically single older women. The really interesting flip side of this is women are much more likely, despite this, to initiate separation, and post-separation, their health improves, which is the only indicator, I think, on which divorce does better for women than it does for men. So I think, I mean, I guess I would just say that if women can separate, and they can separate safely, and they can separate in a way that protects their economic security, then absolutely you are transforming the life of that woman. But also, as you do that for more and more women, even if you just started with the 52,000 that women's legal services are turning away annually, you really start to change the fabric of society and start to work towards some of the systemic drivers and indicators that we've referred to. And just quickly, I just want to say, and I know this doesn't sound like it's going to be quick, but there are 3 other things that happen because of the resourcing. I know, yes, Lara's laughing. I will be quick. One is this double whammy, as I've called it in gender equality, insofar as the funding arrangements that we currently have for legal assistance arrangements, legal assistance services, are actually driving a gender pay gap within our sector. So senior women working in the women's legal sector, like in some jurisdictions, will earn up to to 25% less than their colleagues working in a statutory agency. And I think that the Family Violence Prevention Legal Services have also been driving home that the reality for Aboriginal women working within their sector is even worse. So I think that's the other issue around resourcing. The third thing is, and I thought it was so lovely to hear Tessa reference this when she spoke, was actually that we're totally missing out on the systems analysis available from the experts working in this sector, because every day organisations are making very difficult decisions about resourcing and how much resourcing they put into communications, into community legal education, into policy and law reform, and how much they put into answering the phone and providing services. We have made individual services make that decision. It should be government that is clear that they are pushing us to make that decision. And the last thing I wanted to flag was just Tessa's point about collaboration and how transformative collaboration can be, from the point particularly of access to people that are the most vulnerable and who can really use legal assistance the most. The lack of resourcing is limiting that collaboration. So that organisations that find it easy to collaborate, where collaboration is natural and where it's client-driven, is where there's enough resources and time to actually put that together. And I think about, in my spare time, as Lara said, I'm also the CEO of Women's Legal Centre here in the ACT. We have a fantastic partnership with the Domestic Violence Crisis Service here, which is the 24-hour phone line, where one of our lawyers is placed in with the team at the Domestic Violence Crisis Service. Now, this is a no-brainer, is how it was described to me when we first did it. And yet it has temporary and partial funding for only, I think now, 3 more months. And it's... it's just so frustrating that I think that we're so clear about what the answers are, and yet so it seems willfully blind about what are the things that actually enable those answers to and responses to thrive.
Tessa?
I mean, yeah, I'm glad this is being recorded. I hope it's being shared, because this is an advocacy agenda in its own right, this conversation. I guess to think then, well, what do we do about that? Like all of the really clear points that have been laid out, and thinking about that at an individual and a structural level, thinking about the intersections, thinking about the contribution that legal assistance makes to gender equality beyond what we often narrowly frame as justice. The biggest gap for me in answering what do we do about it is the outcomes measurement piece. And I just think we have to name that here, and we have to hold ourselves accountable. And it might be cheeky me including myself within the sector, given where I am now, but I still, I see this work as being led by the legal assistance sector, but also needing to be, we need to do better around the outcomes measurement piece. And, one of the things I've often reflected on is this kind of siloing of legal assistance, as though it's not a health and human service, as though it's not part of this broader service infrastructure that is core to addressing unmet need in this country, when every day everyone in this conversation, on this webinar, and all of your colleagues know perfectly well that that's the work you're doing. And then, exactly as Elena says, I think that capacity to recognise that, as critical as the immediate needs are of clients, of communities, in terms of individual rights, needs, advice and support, the piece around systemic responses, the piece around the structures that are holding people in disadvantage, there's a really critical legal assistance contribution to that piece as well. And yet we have a really poor evidence base to demonstrate the value of that work, the impact of that work, and therefore to inform sophisticated and strategic conversations about what needs to be funded. So I think, I just really want to name that as a really key missing piece. I do think there's really good work happening to address that within the legal assistance sector, but there have to be partnerships with research and evidence organisations that support that work, and we have to be thinking about that as a bigger than justice problem, and that those partnerships go beyond the justice system, because the impact and the contribution is beyond the justice system as well.
Thanks, Tessa. And I think I can say on behalf of Women's Legal Services, we're very aware of the benefit that being able to do more outcomes measurement would have. The issue is that obviously we are severely underfunded and really don't have the resources to do this work. And so one of the questions I wanted to put to the panel is really, how can the audience, how can other services, how can we get kind of a groundswell of organisations and people helping to fix this problem and working together to kind of identify what these gaps are. Some of them might be, working in partnership, a partnership between the legal assistance sector and ANROWS. Fantastic. It sounds like it was really fundamental to getting our family law reforms on the agenda. But yeah, what else can we be doing, collectively to address these problems for women? Elena, you had your hand up.
Well, I think that's permission to talk a little bit just in response to what Tessa was saying, because, but it is also in an answer to your question, which is when I think about why do we have trouble getting adequate resourcing for legal assistance? I think, look, the first thing that I would acknowledge is this is not a problem that is specific to legal assistance services, that frontline services of all flavours, particularly in the gender-based violence discrimination space and in the domestic and family violence and sexual violence space, there is no I have yet to find an organisation that is not spending a significant amount of time advocating for an increase in resources to be able to meet need. When I think about what the benefit, why I work in this space versus other spaces where I could work in, for me it is around actually that, and this I have to admit to people to being a law school dropout twice over, so I can't actually do this work myself, but what I would observe is that actually legal assistance is squarely in the space of empowerment, not charity. So actually what we do when we deliver legal assistance to women is we walk with them so that they can actually use the protections that there has been a lot of time and energy invested in improving to actually drive outcomes for them as individuals. And I think sometimes, that there is still a very strong bent towards a benevolent charity-based focus in the community-based services sector generally, rather than an empowerment. So I would flag that. I do think that in terms of Tessa's point around evidence base, look, I think that's really interesting, and it's actually her observations, I think, sit between some of the shortfalls that I saw in the gender equality strategy indicators and what I thought should be there. So what I noticed about the gender equality indicators, specifically in relation to gender-based violence, is that they're very incidence-driven. So they're all about the number of women that have experienced domestic and family violence. And absolutely, of course, we should be measuring that, and of course, I'm not going to say anything other that we should be looking to drive those. But I guess I was surprised in some ways to see those as the indicators, given I think we all accept that actually what we will see, the better the responses get, is that number increase, not decrease. So I'm a bit unclear about the context in which we're reading those indicators. Some of the indicators that I think we should be measuring are what percentage of women can get help in relation to gender-based violence and discrimination when they need it. I still think there is this very wide misconception among community members that the reason, that people don't leave violence is because they don't want to, not because leaving is actually an absolutely impossible choice. And I think a lot of people really genuinely think that if there was somebody who wanted to leave violence, it would be as easy as picking up the phone and accessing services. And obviously, we all know what percentage of calls in respective services are actually answered. I'd like to see us measuring what percentage of women exit violence into homelessness. And I'd also like to see us measuring the average income drop post-separation after violence. So I think those are indicators that I would like to see. And I think Tessa's point around actually legal assistance services being able to demonstrate outcome. So how it is that legal assistance services provide the opposite of that, of what is currently happening for women without it, is really, really critical. And I look forward to potentially a possible collaboration with ANROWS to find a way to help us to tap in that, that really impressive level of expertise that ANROWS has access to be able to do that.
Eleanor, I'd actually like to go further. I'd actually like to see tapping into Indigenous women, because we're the largest percentage of domestic violence in the country, and we're not recognised as that. And throughout the 16 services that run the family violence legal services, every one of us would tell you the same story. It's not reported in the media. It's not generated in any way, shape or form that indicates that we are the highest percentage of domestic violence against Indigenous women. And it's throughout the country. It's not specific to any state within Australia. So I'd like to see that result as well, and something done from that, because, as I said, we are the highest percentage of domestic violence within the country.
Yeah, and to talk maybe about what can we do about this, and what can participants do in terms of really promoting this work. I'm sure that most of the people on the webinar work in this space, and so are well across the issues. So it is, I think, going back to what Tessa talked about in her presentation around the strengths of the legal assistance sector, and really trying to build on those strengths. And I think that looking at the roles we have in terms of law reform, advocacy and service delivery, we have so much potential there to really collaborate and create a kind of unified voice and talk about what's needed in a much more active way. And so I think that webinars like this, but also working in your community and working alongside legal assistance colleagues to talk about these issues, and to look at how collectively we can continue to raise the issues and using the strengths as Tessa identified. We've done so much in the law reform space, and it's been really great to see the family law reforms pass last year. But the gap there, of course, is funding the legal assistance to go alongside the reforms. And I think the advocacy work that we've been doing, again, in the example there is a respect at work advocacy, that the work that was done across a much broader sector actually created was instrumental in making sure that the recommendations were implemented. So I think acknowledging that we do play a pretty significant role, but working collectively together on those strengths to really make a difference, and particularly for the most disadvantaged women in Australia, and for women in First Nations communities, I think it's really important that we work collectively to do that.
Thanks, Katherine. All right, well, now we have some time for Q&A. We've got one question from the audience, which is really around the impact of being unable to access legal assistance on victim survivors of domestic and family violence. So the question is, would you agree that when legal assistance is interrupted or denied to women, it subjects the victims fleeing from family violence to more vulnerability and a different form of adversity while being moved through the system, and that this could push traumatic victim survivors further away from recovery and potentially worsen their mental health? So I think the definite answer to that is yes, but is there anything that the panelists would like to add to that? Tessa?
I guess I would give a qualified yes, insofar as I think there's ways to think about legal assistance as a conduit to other forms of service, and all of the work being led by the legal assistance sector around integrated service models speaks to that, health justice partnership and other ways of working. And one of the things I think it's really interesting to think about is, how often a legal need is at the heart of the problems that someone is tackling, and how often actually it's peripheral to really core issues where the legal response is not the most important thing or the most needed thing. So my qualification is, yes, I absolutely understand where the question's coming from, and often that is the case, but also to really value the role that legal assistance can play in connecting people in a context of mental health, trauma, a whole range of other life needs. Legal assistance can play a role in passing people through to the points of the system that they need, and not always assuming that the legal response is the core that's needed.
Elena, maybe you might want to speak to kind of our integrated approach and how that kind of works for women.
Yeah, I think what I would say in response to this question is the the actual legal issue is something that we often focus on, but I also think there is a question here really for us about process. And actually one of the things in many of the services that we, member services of WILSA, that we spend a lot of time talking and thinking about is some of the particularly in the space around gender-based violence, including sexual violence, the role that legal assistance can play in reversing some of the damage done, particularly around the vitiation of autonomy, of choice, and of empowerment of women actually engaging with and driving what happens for them. And I think it is true that that partnership is really critical. And in the service I run, really the first partnership we had to get right was the partnership, an internal partnership between lawyers and social workers, and as the service has expanded, also between lawyers from different practice areas. So I think that if you put the client at the centre of the problem, it does actually drive you to do what Tessa is doing, and as suggesting is necessary, and really look at what is this woman's life, and what is the thing that is the most important to her. If we're actually about choice, empowerment, trust, and collaboration, then we have to start that with clients in the first instance. So so I would agree with that and say there's been some great inroads in service development to help that, to widen that. And I think just adding the number of people that work in, and certainly just from my perspective here in the ACT, that the number of social workers and others, allied professionals that we work with, has absolutely opened up the relationships and the avenues for clients that we assist. And Tessa's also right, sometimes the actual legal advice that people need is, this isn't a legal issue. And vice versa, it's getting that right. Or actually the best response to this legal issue right now is to do nothing. And so I think that if we put the problem at the centre and not the services we're delivering at the centre, you get development of some good solutions.
All right, we don't have any more questions in the chat, but everyone just please feel very free to ask questions. There will be no judgment or analysing of your question. We will only provide the best answers that we can. I might then just ask one of my own questions. So why do you all think it is that when we talk about gender equality, we talk about ending violence against women, often legal assistance is missed out from the conversation? And maybe there's an increasing understanding, but still kind of a way to go to get people to think about why access to understanding your rights and entitlements, having protections as you navigate different systems, why that could be so vital to ensuring that women can leave violence and abuse, and also can gain economic independence, all the types of things that we've been talking about today.
Laura, I'll just answer that from an Indigenous perspective. It's not just fleeing violence, it's fleeing the family. And for Indigenous women, that can be quite hard because they have no other support outside that current family structure that they're in. To be able to flee that situation, it becomes a situation of they're not only then abused by their current partner, but by the family. And it becomes quite a cultural issue. And I've got one particular client at the moment. She has been not only domestic violence created by the partner, but by the family. The family have also created actual acts of domestic violence. So it's not just a one person, one relationship. There's many facets to it that add to the level of domestic violence that she's enduring. And we're trying to get a victims assist claim through for her, and she's so terrified that she doesn't want to actually go through with the victims assist claim. So it's not just one facet or one relationship, it's a multitude of relationships that she has to navigate to get away from the situation. And if she does get away from the situation, her vulnerability then increases, as we've said here today, it with homelessness, with lack of access to resources, with lack of access to finance. And then there's also the added layer of the historical nature of this country, insofar as we don't trust government organisations. We don't come to lawyers for that assistance, because there's that level of not only being vulnerable, then it's also the layers then of as I've said, you know, there's the layers to it. It's not just a clear cut, I'm fleeing my partner. There's so many layers to it from an Indigenous perspective.
I wonder if I can just really quickly add on to that. I wonder if it's that it's, you know, just going on to Kathleen's point about, like, yeah, women, especially from an Indigenous perspective, are hesitant to access the services for the various reasons. But if actually, you know, the idea of legal assistance, or the sort of availability of legal assistance, gets lost in the sort of, you know, the sort of, I wouldn't say narrative, but gets lost in, you know, what we talk about when we say prevention of family violence, or prevention of violence against women and girls. I mean, we talk about the sort of macro systems of, okay, we've got legislation, we've got the police, this is how the systems are all going to work together, and often legal assistance gets subsumed within the sort of, you know, criminal justice response, even though actually maybe there should be, you know, more prominence or more light shed on the sort of lever of legal assistance, because, as you know, different people on the panel have highlighted, that actually it's one mechanism through which, and that's certainly the case with, you know, the member services, it's one mechanism through which other sort of services get brought into the fold. So it's almost like it is almost like the gatekeepers, the sort of, you know, the first touch into the system of healing, or journey into healing.
And I'd like to probably add on to that too. A lot of domestic violence applications are made by police. Indigenous women and Indigenous families do not trust police for various historical reasons. And then there's the misidentifying of our actual perpetrator. And another issue I find as a legal practitioner is the difference in legislation. In New South Wales and Queensland, for instance, it is so complex in New South Wales compared to Queensland. And it's that complexity. And a woman going through domestic violence from an Indigenous perspective, she's not going to endure going to court, going to the police station, going to the hospital, because they're all government organisations.
Can I pick up one other point? I think that there's, you know, the evidence is really clear. People don't think about their problems as legal problems. They don't think about legal services as being available for them, and they ultimately don't have trust in lawyers in the same way that they have trust in other touch points, particularly in a service context like health systems. So I really hear that, you know, all of those additional contextual factors, Kathleen and Priya, that you've talked about, absolutely hear that. And I guess I want to add to that, the thing that really came through in my work at Health Justice Australia was the flip side of that, where people do understand legal process, do know about the existence of legal assistance services, and hold really strongly against the role of those legal assistance services, because they see it as bringing conflict into systems that otherwise should be therapeutic. And so I think we've got some other challenges to address at a systems level, this sort of perception that a legal process is inherently adversarial, which really flies in the face of the really, you know, the critical work around asserting people's rights and empowering people that we've heard about here. But I think that is a challenge that we probably don't name as much as we need to. And then if we see that as a challenge in the service system, there's space to think about, well, who can be the allies, and how can we use collaborative approaches to really tackle that, so that some of the people who might be advocating for the addition of the presence of legal assistance might be the health colleagues in a health justice partnership, or the social service, or the family violence protection workers in a different kind of collaboration. So I think that's something else I would want to just flag.
And I'll go on from that. With our women and our victims of domestic violence, we actually do cultural healing rather than your mainstream medical health healing. We go through, as our service, we provide cultural healing, and we provide that one-on-one with the client. And we are getting some pretty good results from that, especially in child protection too. Mothers that have had substance abuse are now turning another corner through that cultural healing, which is what they've been missing in their lives. So yeah, there's another way to look at it as well.
All right, we might move on to a final question. I'll just go in kind of order. So the first question that got in was, how can the private legal profession assist more in this space?
I'll try and give a very quick answer. And I think it's absolutely through supporting the legal assistance sector as much as possible, through being aware of the role that private practitioners play in legal aid, and also working alongside and providing pro bono support to CLCs where appropriate. But I think also talking about just how hard, being very vocal and vocal and upfront around how hard it is to actually access legal assistance. And so there is an assumption, particularly when I'm doing advocacy, that legal aid is something that anyone can get if they need it, and that there's not an issue in terms of accessing lawyers either, which we have massive challenges around as well. So I think it's just raising awareness as much as possible within the legal fraternity and beyond around the under-resourcing and the impact that can have on women and children in particular.
I'd like to, if I can, how the private sector can help. You can work with us. Work with us. It's simple. We've had private practices that we work with on a pro bono basis. We've got barristers that work with us on a pro bono basis. And we get great results from that. If we can't, our motto at AFLSQ is, if we can't do it, we find somebody that can. And most of those private practices are the somebody that can. And you create those relationships down the line, because you know that your client is not going to be left when the end of our funding comes. They're going to be taken care of.
Yes, I would endorse those, and to say I think the first thing they can be doing is to be mindful about their own practices and how their own practices can both inhibit and drive access. So I think one, I've seen some really appalling practice of people in the private profession basically exhausting bank accounts, parents' mortgages, things like that, before referring people on to our services. I think, that seems like an easy thing to stop doing. The second thing is also being thoughtful and interested in some of the, what percentage of time you actually have available to volunteer, as Kathleen has said, is to actually provide services through our service network, and particularly community-based services. There's I think here in the service I run, that the pro bono relationships we have probably add about 25% to our capacity every given year. So it's a really significant thing. But also thinking about how you could structure your own fee arrangements in a way that is actually about providing access, particularly to what we all call the missing middle. And I think there's some really interesting examples of private practitioners that are purpose driven as well as profit driven, obviously, doing that. So I think that's something that people can think about. And I think the other thing is absolutely advocate. I was speaking to a group of women lawyers last week, and as I was saying, the power, the networks, the institutional power that lawyers as a profession have is really significant. And actually the sector being backed in by the Law Council and other representatives of the private profession, I think have been really profound in terms of some of the outcomes and the profile of the issues that we're talking about.
Thanks so much, Eleanor. Elena, that was actually a really that was the point that I had in my head. If there was, a piece around allyship where, you've got the private sector, you've got them advocating for, for a lot of the workforce issues that the public, the sort of not-for-profit legal assistance sector faces. I think that would be a dream. But I'd like to thank, everyone. We've run out of time, so I'd like to thank everyone for their insight into this International Women's Day webinar. It's been extremely insightful and, a real advocacy piece. and it's being recorded. So hopefully that will be at some point made available. So I just want to thank everyone, especially our panel members, for joining us today. Thank you all.
Thank you.
Thanks, everybody.